Before we proceed to examine Rule 412, the Rape Shield Law, I would just like to engage in a brief historical digression. Prior to Rule 412's enactment in 1978, victims in sex offense cases were often attacked by zealous defense attorneys. The victim's character was, quote, put on trial in the vernacular, as defense lawyers would use creative arguments to bring in evidence of a victim's sexual behavior or sexual predisposition, often in cases involving an alleged consent defense. As indicated a moment ago, Congress enacted the Rape Shield Law in 1978, which was designed to protect victims and other witnesses in sex offense cases, and that statute was amended significantly in 1994. Let's now look at the general rule, Rule 412. In general, evidence of other sexual behavior or sexual predisposition of an alleged victim is barred in any civil or criminal proceeding involving alleged sexual misconduct. 4 comments about this rule. First, the ban applies for both substantive and impeachment purposes. You can't bring in a witness's sexual behavior or sexual predisposition to impeach that witness. You also can't bring it in for substantive purposes to prove, for instance, consent. Second, the rule applies to any alleged victims. An alleged victim might not even be a party. If the witness happens to have been an alleged victim, then the Rape Shield Law will protect that victim from having his or her sexual behavior or predisposition trotted out in front of the jury. Third, the legislative history offers an indication about what is meant by the term sexual behavior and suggests that it should be construed very broadly. The advisory committee notes suggest that sexual behavior includes any evidence that implies sexual conduct, such as evidence about the use of contraceptives or birth of a child outside marriage or the presence of a sexually transmitted disease. Sexual behavior might also include activities of the mind, such as fantasies or dreams. So a diary or journal that contains certain sexual fantasies would be potentially inadmissible under Rule 412. Fourth, the legislative history also offers an indication about what is meant by the term sexual predisposition. The advisory committee notes suggest that sexual predisposition covers and bans any evidence relating to the alleged victim's mode of dress, speech, or lifestyle. A reference to the fact that the alleged victim was wearing a particular type of clothing might fall into this category. To reiterate, Rule 412 generally is a broad ban on the introduction of evidence of any other sexual behavior or sexual predisposition evidence of an alleged victim in any civil or criminal proceeding where the allegations include those of sexual misconduct.